Good afternoon. My name is Donna Marie Collins. I'm the hearing examiner that will be presiding over this appeal hearing. The purpose of this hearing is to consider an appeal of a decision of the Boca Grande Historic Preservation Board to deny an application for a special certificate of appropriateness. Appeals are limited to the issues set forth in the notice of appeal. I do not have the jurisdiction to consider issues outside the issues raised in the notice. In the context of an appeal, the record is finite and may not be expanded to include new evidence outside the existing record. The testimony and evidence presented to the Historic Preservation Board consists of the entirety of the record in this case. That record must contain competent and substantial evidence to support the Historic Preservation Board's decision. There may be no supplementation of this evidence today, and the record may not be expanded. Accordingly, I will be limiting testimony to legal argument by the parties. Argument should be confined to the scope of my authority, which is limited to a determination of whether the Historic Preservation Board afforded procedural due process, whether the Historic Preservation Board applied the correct law, and whether the record before them contains substantial competent evidence to support the actions that they took in denying the special certificate of appropriateness. I will conduct this hearing in an informal but professional manner. The order of presentation will be as follows. First, the appellant, then county staff. Then there may be questions posed by myself, and we will conclude the hearing. I will permit up to 1 hour for the parties to speak. I know that there are members of the public here. This is a public hearing. It's open to the public. We have a court reporter here, and the hearing will be transcribed. That document is a public record and is available to anyone. It should be accessible both online, and you may request a hard copy, but heads up, the statutes require that we charge you per page. It's not a lot, but you're better off getting an electronic version if that's possible. I know that the administrative code references the procedure for a hearing, and it talks about public input, but that applies to both zoning and appeals, and in the context of the appeal, I cannot expand the record. All the testimony and evidence that I can consider are already in the transcript that's been provided to me. And for that reason, I'm going to limit public testimony today and restrict it only to legal argument of the parties. I will administer the oath to those of you who wish to speak on the record. Is everyone ready? Okay. Please raise your right hand. Do you swear or affirm the testimony and evidence you give today will be the truth?
Yes, I do.
Okay, I'm ready to begin.
Good afternoon, Madam Hearing Examiner. My name is Megan Strayhorn. I am an attorney with Strayhorn Persons, Mullica and Fisher, here on behalf of the appellant applicant 161 Gilchrist, LLC, which is the property owner of 161 and 181 Gilchrist Avenue in Boca Grande, Florida. At this time, we will request to reserve 5 minutes for rebuttal purposes.
Okay.
And out of the 3 areas right for hearing examiner review, we do argue that the Boca Grande Historic Preservation Board erred in this case for 2 reasons. 1, they failed to apply the correct law, and 2, there was no competent substantial evidence to support the denial. Now, the Boca Grande design guidelines governs non-contributing properties.
Can I ask you to speak from the podium, please?
Yes, ma'am. My
Thank you.
apologies.
And
Slow down.
Slower.
I have a habit of speaking very fast, so I will do my best.
We may interrupt you from time to time to slow down so she can get everything down.
Please
And
do.
you're not the only one we do it to, so.
Please do. I used to be able to speak much quicker. Now that I'm pregnant, I will catch myself because I won't be able to breathe very well. So let me continue. As I'm sure you're very well aware, that Chapter 22 of the Land Development Code does govern the Boca Grande Historic Preservation Board for non-contributing properties. Those are governed by the Boca Grande Design Guidelines. For contributing properties, the Secretary of Interior's Standards for Rehabilitation Control. The reason why I bring this up is this particular application did involve 2 parcels. One was a non-contributing and one was contributing. However, the sole issues raised by the Boca Grande Historic Preservation Board pertained to the non-contributing properties, so only the design guidelines are going to be addressed, which is the only reason why I bring that up. Now, the board failed to apply the correct law in this case for three reasons. First, the board applied the incorrect burden of proof. Second, the board erred in basing the denial on a bench located on 161 Gilchrist Avenue. And finally, the board erred in basing the denial on the current features of the property. Before I get into kind of my argument, I do want to hand out, and I apologize, I just have paper copies. I'm going to, may I have permission to approach? Okay. I'll give one to Zach. I think I have 4. 1, 2, and then of course Leah. And for the record, these were all presented at the public hearing in April. I'll just be reutilizing them. And I do have an extra one just in case we need it. Excuse me. Turning to my first prong, the board failed to apply the correct burden of proof to deny this special certificate of appropriateness because the board's denial was unreasonable and was not based on competent substantial evidence. Now, as outlined in the brief that was prepared, the Boca Grande Historic Preservation Board, these cases are quasi-judicial in nature. So there has to be some type of safeguards in place, although they are not. And they are very akin and analogous to rezoning cases. They're dealing with individual properties, small properties, what can be permitted or what cannot. And the reason for this burden shifting analysis that was outlined in the Board of County Commissioners of Brevard County versus Snyder is to really provide safeguards for zoning cases. And in here, we do believe and we do argue that that burden shifting analysis should also apply in Historic Preservation Board cases. Now, we know that the standard of proof, as you had indicated, is there must be competent substantial evidence, but the Land Development Code is silent as to that burden. So we do argue that once the applicant, the appellant, meets that initial threshold of establishing competent substantial evidence, that the board must show that their denial was based on also competent substantial evidence or is not unreasonable, arbitrary, or discriminatory. And in this present case, the board cannot do so. So here in the present case, Lee County staff did recommend approval of the application. There is case law that states that the staff recommendation is competent substantial evidence enough. So the burden should have shifted at that point. But the appellant went above and beyond. There were 4 expert witnesses that testified at the hearing. We had 2, my apologies, we had 2 licensed architects from Daly Jansen Architects who are very familiar with the Boca Grande Historic District, the Secretary of Interior standards, and there were 2 certified planners, one of which was Gloria Sego, who's probably the leading certified planner for historic cases, and her expert testimony dealt primarily with the design guidelines, Secretary of Interior standards. We also had certified planner Tina Ekblad, who testified in regards to the land development and the compliance thereof. Now, turning to the pages of which I've distributed, looking at the first page, this is just kind of the location map of the property. So the expert testimony and initially really touched upon the fact that this proposed construction spans across 2 lots. So it goes from the Gulf Front all the way across to Gilchrist Avenue, and which is also evident in the next aerial, which is present. My apologies. So the 2 architects testified, provided expert testimony. There was ample testimony regarding the form and materials and style, however, that's not in contention here today. But they did explain that there were multiple architectural techniques employed to reduce the overall visual mass of the property. So for example, the 2-story proposed residential structure is located, or was to be located, on 161 Gilchrist, which is the Gulf Front section. So that 2-story residence sits 160 feet away from Gilchrist Avenue. It does not impact the streetscape at all, and with the large banyan in front of that's located on 181 Gilchrist, it would be impossible to see. Another mechanism for reducing that visual mass was a site-specific study that was done that lowered the elevation. So rather than having it be a foot above grade for elevation, it was just 5 feet above elevation. So as Mr. Jansen provided expert testimony, that it allowed for a more traditional 2-story residential structure above an elevated crawl space. Based on all of the expert testimony that was presented, the board should have, the burden should have shifted to the board to show that their denial was not unreasonable, arbitrary, or discriminatory. I'm looking at the second page that I distributed. For example, one of the neighboring properties, I'm looking at the northwest neighbor of 200 Banyan Street, is a newer construction. So as will be discussed later on in the argument, that construction did go in front of the board, and it has a very similar footprint than the proposed construction here. And Peter Blackwell from the Lee County staff did explain that the staff recommended approval because they thought it was consistent with that proposed construction. So the board's acceptance of a prior proposed construction very similarly situated to ours, but with denying the present proposed construction, shows that there was unreasonable, as well as there is no competent substantial evidence to support the denial. So even if, Madam Hearing Examiner, you disagree with this burden shifting analysis, it nonetheless stands that the board's decision cannot stand because there was no competent substantial evidence to support it. So turning to that second prong, the board erred in basing the denial on a bench because the bench was not part of the application to begin with. I'm sure you've read through the record, and there was a lot of public comment pertaining to a bench that was located on 161 Gilchrist Avenue. Assistant County Attorney Amanda Swindell did explain to the board at the time of the public hearing that there was no special significance of the bench. The bench is located on a non-contributing parcel and has no special historic designation or protections therein. The special certificate of appropriateness application that was presented to the board was solely pertained to a proposed construction of a 2-story residence on 161 Gilchrist and a proposed construction of what I'll call accessory structures on 181 Gilchrist Avenue. It did not include any request for demolition or removal. So the board's reliance on the bench is misguided and misplaced. My apologies, I just want to make sure I go through my notes before moving on.
Take your time.
And finally, the board erred in basing the denial on the current features of the property because doing so contravenes legislative intent. And this Florida statute that I'm referring to is Florida Statute 55379. It was recently amended in 2022. And I will summarize the statute. It allows private property owners to demolish structures, whether they be in historic districts or not, if they are in a coastal high hazard area, and if that the lowest floor sits below elevation. So it gives private property owners the ability to remove unsafe structures or structures that might be prone to flooding. But there's a subsection 26C, that provides that if a single-family residential structure is demolished pursuant to a demolition permit, the local government may not impose additional regulatory or building requirements on the new structure that's to be constructed, which would not otherwise be applicable to a similarly situated vacant parcel. In other words, you can't compare what the proposed construction is with what was there at one time. Now, in the present case, Board Member Patterson specifically stated that she found, in her motion, that the proposed construction was inconsistent with the guidelines because it was, and I'm paraphrasing here, it was bigger than what exists there, so therefore it is inconsistent. This type of statement is per se evidence that that is an inapplication and an incorrect interpretation of the design guidelines as it was applied in this case. So for the above reasons, we argue that the board failed to apply the correct law in this case. However, as previously stated, if the hearing examiner does find that they did apply the correct law, the decision would still not stand because there's no competent substantial evidence to support the denial. So moving on to the second prong of the argument, there's no competent substantial evidence to support the denial because any of the arguable evidence that was presented in opposition of the application was brought by lay people and was refuted by the expert testimony. So what exactly is competent substantial evidence. The DeGroot versus Sheffield case, which is a seminal Florida. DeGroot, DeGroot v. Sheffield, Sheffield. It's a Florida Supreme Court case from 1957. States that substantial evidence has been described as evidence that will establish a substantial basis of fact from which the fact at issue can be reasonably inferred. As such relevant evidence, as a reasonable mind would accept as adequate to support a conclusion. The evidence relied upon to sustain the ultimate finding should be sufficiently relevant and material that a reasonable mind would accept it as adequate to support the conclusion reached. So to this extent, the substantial evidence must also be competent. Now, this general rule has further been defined and narrowed, so we know that general statements in opposition to a land use proposal must be disregarded. We know that testimony, and these are directly from the brief that was submitted, testimony that is contradicted by documentary or video evidence is not legally sufficient to support findings or conclusions. And finally, unreliable evidence cannot be construed as competent substantial evidence. Now, there was no competent substantial evidence in this present case because there was no competent substantial evidence presented demonstrating that the bench was a historic feature of the property. There is no competent substantial evidence regarding that the scale of the proposed construction is inconsistent with the block or district, and there's no competent substantial evidence that the mass and scale of the proposed construction is inconsistent with the structures of the block or surrounding areas. So turning to the first prong, there's no competent substantial evidence that the bench falls under Design Guideline 2.1 because there's no verifiable, reliable evidence presented connecting the bench to 161 Gilchrist Avenue or attesting to the historic nature. Attesting to the historic nature thereof. My apologies. There was quite a bit of public comment regarding the bench. However, a good bit of it was letters presented. They were hearsay testimony. Now, granted, hearsay is admissible for quasi-judicial proceedings. However, hearsay statements are inadmissible in courts of law for a multitude of reasons. At the very basis, hearsay testimony is untrustworthy, unverifiable, and unreliable. And hearsay cannot form the sole basis of competent substantial evidence. And as previously stated and indicated, the assistant county attorney did indicate during the hearing that at the current time there was no specific, and I'm paraphrasing what she did tell the board, but there was no specific protections or historic designation of that bench located on 161 Gilchrist Avenue. 161 is a non-contributing parcel, and that bench is a fixture on that parcel, and there was no competent substantial evidence to refute that. So moving on to the latter two, the other two reasons for the denial are very similar, but I'll try and separate them as much as possible. So there's no competent substantial evidence that the scale of the proposed structure is inconsistent with the character of the block or district because the only expert evidence presented showed that the scale is in fact consistent with the district. So I find it helpful to look at what Design Guideline 4.1 says, which is contemporary styles should be harmonious in form, material, and scale with the character of the block or district. As previously stated, the form, material is not in contention. It's really that scale that the board harped on. So when looking at scale, one of the attributes is height. So certified planner Tina Ekblad, as well as the architects, did testify that the proposed height of the structure is 31 feet. This is well within the maximum height permitted by the Land Development Code for Boca Grande, which is 38 feet above grade, and it is consistent with the neighboring properties, which I'll show in just a minute. To further exemplify the similarity in mass and scale, when looking at the north elevation, this is what was testified by Tina Ekblad, provided expert testimony that the north elevation of 161 Gilchrist was 89 feet in length, whereas according to the 200 Banyan Street, it was 107 feet in length. Now, there was some comments about lot coverage. This property consists of two parcels, 161 Gilchrist and 181 Gilchrist. And it consists of proposed construction of a single-family residence and accessory structures which spans across those two parcels. So when you're looking at those two parcels together with the proposed construction, that lot coverage is 27%, which is much less than the 40% requirement listed in the Land Development Code. And that is undisputed and unrefuted in the record. So returning to my final point, there's no competent substantial evidence that the structure is larger than any immediately surrounding residence because the unrefuted expert evidence demonstrates that the proposed structure is consistent. And this is where the aerials come into play. So Design Guideline 4.3 does state that new buildings should appear similar in mass and scale with historic structures in the block or surrounding area. Now, the board erroneously found that at more than 13,000 feet, the structure is larger than any immediately surrounding residence on the block. Mr. Peter Blackwolf with county staff explained, I think there was a specific question of what does this mean. Mr. Blackwell explained that when looking at historic structures, it's structures located within the historic district. It's not limited to contributing versus non-contributing. It's structures located in the historic district. Now, looking at the exhibit, I'm looking at page 2 of the pages that I handed out. The subject property consists of 161 and 181 Gilchrist. Just so for future reference, to the northwest is 200 Banyan, which is a non-contributing parcel. To the northeast is 210 Banyan, which is contributing, and then across Banyan Street, which you can kind of see is 211 Banyan, which is also non-contributing. To the immediate south are 2 contributing properties. One is a smaller, and I'm going to call it the southeast corner, and then, of course, directly underneath the south is a much larger contributing parcel property. And the following 2 aerials just show that block a little bit wider. So this is the east elevation. You have Banyan Street on the north, Gilchrist Avenue on the right, on the east side, and then on the west is the Gulf Front. And the following aerial is just a west, kind of looking from Banyan Street is on the bottom of the page, looking up towards the block. So they're just the same block with different perspectives, which allows you to see the large homes that surround the subject property, I should say. I do want to draw your attention to, there were 2 exhibits that were presented during the hearing in addition to what was just presented. So I'll first turn your attention to what is identified as Exhibit 3, and this was included in the attachments with the notice of appeal as well. This compares the 161 and 181 Gilchrist, the proposed construction, with that northwest neighbor. So this demonstrates a very similar height, so you can see that the height is very similar with comparing those 2 structures. And also, there's a bit of confusion comparing this 13,000 square foot number. One of the public comment was pulling some numbers apparently from the Lee County Property Appraiser's website and trying to compare this 13,000 square feet with these other numbers. So specifically referring to that 200 Banyan Street, which is what this elevation shows, there was numbers that it was 4,000 or 5,000, but as Mr. Jansen, the architect, explained, comparing a gross square footage, which is what that 13,000 square foot is, to a living area square footage is akin to comparing apples to oranges. So what is not seen on those numbers or on the paper is the actual visual mass of the building. So when you're looking at this elevation, you can see that the bottom floor of 200 Banyan, I'm looking on the left side of the page, is actually, it's a full grade above elevation, or a full floor above elevation. So the first floor is entirely empty. So although the height looks the same, only the second floor is under AC. So when you're looking at living square footage numbers, that living square footage number cited for 200 Banyan is only limited to that second floor. What is much more appropriate to compare would be the gross square footage, and this is what our expert testimony from Tina Ekblad, Gloria Sago, and the architects explained that the gross square footage of 200 Banyan Street is much closer to 11,000 square feet, which is much more consistent with the proposed construction of this site. My apologies, I just want to. And I will turn your attention finally to the last page, which is identified as Exhibit 4. This shows the comparative footprints of the proposed construction with the northern structures. So we have 200 Banyan on the northwest side, as well as 211 Banyan, which is across Banyan Street. And as you can see, when you're looking at the individual lots, the proposed construction spans from over 2 lots from Gulf Front all the way to Gilchrist Avenue, whereas the others are only limited to 1 lot. So looking at the footprints, you're looking at the footprint of the proposed construction is 7,600 square feet. When you're looking at the footprint comparing to, or the gross building area of 14,000 square feet of the proposed, the building area of 200 Banyan, which is 11,000. So and the 211 Banyan is 10,000 square feet. So when looking at the footprints and you're looking at the visual mass of the buildings, this is a much more appropriate measuring tool than taking a gross area square footage number and comparing it to living square footage numbers, which was, I think, drew some of the confusion in front of the board during the public hearing. Now, in conclusion, the appellant does request that the hearing examiner finds that the board apply the incorrect law and that there is no competent substantial evidence exists to support the denial, and thus remand the case back to the board to approve the SCA application. My apologies.
Thank you.
Thank you very much.
Good afternoon, Madam Hearing Examiner. For the record, Amanda Swindle, Senior Assistant County Attorney. I'm going to make my presentation pretty brief today and focus exclusively on what I feel is really the only issue before you today, and that's whether or not there's competent substantial evidence on the record to support the Boca Grande Historic Preservation Board's denial of the Special Certificate of Appropriateness. I agree with appellant regarding the appropriate standard of review and the well-known 3-prong test that Florida courts traditionally apply to quasi-judicial local government decisions, and that's articulated in LDC 34-145A3H. So the first prong, did the Historic Preservation Board afford due process? The appellant makes no arguments regarding this prong, so it's easily dispensed with. The second prong, did the Historic Preservation Board apply the correct law? The county agrees with the appellant that the correct law to apply are the Boca Grande Historic Design Guidelines, and that is exactly what the Historic Preservation Board did. They applied the historic guidelines to the subject application. Appellant raises a couple of issues that I think are kind of easily dispensed with preliminarily. As the county stated in its response to the order to show cause, arguments that the actions of the Historic Preservation Board are superseded or preempted by state statute are outside of the authority of the hearing examiner to hear in this appeal and should be disregarded. Regarding the appropriate burden shifting process, appellant cites the Snyder case as well as Lee County v. Sunbelt. As stated in our response to the order to show cause, both of these cases dealt exclusively with rezoning requests, and the holdings are specifically tied to the application of Florida's Growth Management Act to a property owner's request for a rezoning. The Historic Preservation Board case is not a request for rezoning, obviously. In appellant's response, they also cite a case, Broward County v. GBV, as evidence that Snyder is applied to a site plan review. But if you read that case, the court actually doesn't cite Snyder for the burden shifting process. It cites another case, Irvine v. Duval County Planning Commission. And if you read that case, what you'll find out is that the dissenting opinion, which is the opinion that was eventually adopted by the Florida Supreme Court, went to great lengths to distinguish the burden allocation involved with the rezoning request as opposed to a special exception, which was the decision that they were reviewing. And in fact, the burden shifting is actually, or the burden is actually heavier on the administrative body in cases like a special exception, where there's more concrete standards. My point here is basically that just courts haven't articulated a single burden shifting standard for all quasi-judicial cases. It really depends on the nature of the issue before them as to what the proper burden allocation is. You can analogize a historic preservation case to these cases, but I haven't found any actual cases that apply that either the Snyder burden shifting or the Irvine burden shifting to the historic preservation cases. And to the extent that appellant argues that those burden shifting processes should be applied here, I would say that again is outside the hearing examiner's scope of review under the Land Development Code. And it's also an issue that wasn't raised to either county staff or the Historic Preservation Board at the hearing. And Land Development Code 34-145A7 prohibits the hearing examiner from considering issues not previously submitted to county staff, administrative official, or the board whose decision is being appealed. However, even if you feel that the Snyder burden shifting process is the appropriate burden allocation for historic preservation cases, I feel that the Historic Preservation Board satisfied this burden by demonstrating that there is competent substantial evidence on the record to support the SCA denial. So with that, I will get into the principal case. So the Historic Preservation Board denied the special certificate of appropriateness based on failure to meet 3 design guidelines. The first design guideline was Design Guideline 2.1, and I'll just read it to you. This requires the Boca Grande Historic Preservation Board to, quote, identify, retain, and preserve features that are important in defining the overall historic character of the site, including driveways, walkways, lighting, fencing, signage, benches, fountains, terraces, water features, vegetation, and potential archaeological features. So this is a list of many things that would be unpermitted structures that, again, a property owner would have every right to remove. But again, they are mentioned in this guideline as the responsibility of the board to take steps to protect and preserve. And again, this is a guideline specifically applicable to non-contributing properties. So I don't think the fact that it's a non-contributing property and an undesignated bench really takes it out of this guideline. I think it's pretty clear that this guideline is meant to apply to features such as this bench at issue. So the appellant argues that the bench is not a part of the application and shouldn't have been considered. But the application materials do show the bench, describing it as an existing sitting structure to be demolished on the demolition site plan dated January 4th, 2023. And in the appellant's case before the Historic Preservation Board, their representative, Mary O'Bannon, essentially opened with testimony about the bench. And I'll just read that to you here. Before I begin, I want to address the concern that I would say the majority of you have in this room today, and that is the whispering bench. Although the whispering bench sits on a non-contributing parcel, everyone needs to know that I have been diligently working for a very long time to relocate and preserve the bench. Knocking down the bench and demolishing the bench has not once been on my radar. And this is within the transcript at pages 36 to 38. So I think the appellants made the whispering bench a part of the application by including it on the demolition plan and by essentially opening their case with the discussion of the whispering bench. Regarding the argument that there's no competent substantial evidence on the record correlating the bench to the property or identifying the bench as historic, again, there was the testimony from Miss Mary O'Bannon herself discussing the bench's long history on the property, its association with Miss Louise DuPont Crowninshield, who is a well-known historical figure on the island, and Miss O'Bannon's efforts to relocate and preserve the bench. In addition to the appellant's own testimony, testimony from members of the public with actual knowledge of the bench. This included Sue Sliger, who was the former property owner of the subject property, Tom Bowers, a neighboring property owner who's lived on the island for many years, and attorney Michael Haymans, who the board did accept as having some expertise in historic preservation. And he was actually able to produce a photograph of the bench dating back to 1936. So I think that the historical provenance of the bench was established on the record, both by testimony from members of the public with actual knowledge and by the appellant's own representatives. In addition, the Boca Grande Historic Preservation Board members are appointed to the board based on their historical knowledge and expertise, and are empowered under Land Development Code 22-1, subsection 2, to determine the historical significance of a designated historic resource. So the Boca Grande Historic Preservation Board members themselves, many of which were familiar, have actual knowledge of the bench, their testimony during the hearing, I think, does also constitute competent substantial evidence on the record regarding the historic significance of the bench. So you would, I believe it's footnote 36 of the appellant's summary of their argument notes that the bench is no longer there anymore. So the county does concede that this is now, would be a moot point for any future application for the property. The property owner was within his right to remove the bench. He did not require a permit to remove the bench, and any future application, this bench would not be an appropriate consideration for the board. But on April 12th, when the case was before the Historic Preservation Board members, and many of the citizens of the island were there discussing it, it was an important factor. And again, that guideline actually requires the board to try to take steps to preserve things like that. So the next two guidelines are, as Ms. Strayhorn said, are closely related and have to do with the general size of the proposed residence. Guideline 4.1 deals with the scale of the property. So scale basically is the size of one thing and compared to the size of another. So we're talking about lot coverage here. And even though the applicants, or the appellant here, is treating this as one unified lot, these lots are not actually combined. They have two different strap numbers. Apparently, according to data from LIPA, they were under a common strap number until 2017 when they were split. And I believe there's also a current certificate of appropriateness application to construct a separate cottage on the 181 lot. So again, the property owner intends to preserve their development rights for both parcels separately. And under the Land Development Code, a parcel or a lot is defined as a parcel of land considered as a unit. So when staff reviews cases for compliance with zoning regulations, they do so based on strap number. And so I will pass out, this was included in, oh, I'm sorry, wrong one. This was included in applicant's presentation materials before the Boca Grande Historic Preservation Board as the architect's presentation. So as you can see, while the proposed construction might cover 27% of both lots together, looking at 161 individually, it actually covers 42.5% of the lot. The maximum lot coverage in the RS1 zoning district is 40%. So the fact that the proposed lot coverage exceeded the maximum lot coverage in the Land Development Code, I think, is evidence that there was an issue with scale with this proposed residence. And again, this was not testimony from lay members or members of the public. This information comes straight from the applicant's presentation. And I believe it was also corroborated by Mr. Carlos Santamaria when he testified at the hearing at the transcript, pages 121 to 122. So that was guideline 4.1. Guideline 4.3 is more to do with mass and scale. So here I'm going to talk about the size of the building. So this page was from the applicant's presentation, and I believe Ms. Strayhorn was just showing you a copy of this, but I have one that's highlighted. So again, in taking a look at the proposed construction in relation to adjacent properties, we have what the appellant's own architect told us were the correct numbers to use, which was the gross building area. And if you take a look at those numbers and you do the math with a calculator, hopefully, because I wouldn't want to do that in my head. But if you do the math with a calculator, you will find that the proposed residence at 14,099 square feet is over 24% larger than 211 Banyan and over 29% larger than 200 Banyan. So again, these were the numbers that the architect told the board were the appropriate numbers to use. And doing that math, the fact that it's 24 to 29% higher or larger than other approved residences, I think was an appropriate factor for the board to consider in determining whether the mass of the building was too much.
So does the mass in this calculation include the proposed detached garage?
I believe, I'm not sure. I wish the appellant's architect were here to answer that.
And where is the property line in relationship to these two red structures on this exhibit that you've provided from the record?
Again, I just pulled this exhibit straight from their presentation because the architect told us these were the correct numbers to use in comparing the buildings. And if you look at his...
I ask only because you made the argument that they're intended to be two separate parcels.
Yes.
It appears it's being developed as one parcel with outbuildings when you present this exhibit that was presented to the board. So I was just asking for clarification on that issue because I think it's relevant to the evidence that they considered when determining whether lot coverage was more or less.
I'm not sure I understand your question here then.
Well, I want to know where the property line is.
Okay. Maybe appellant could...
Because it appears to me, based on the exhibit that you first gave me, this other red structure is actually on the other parcel. So that would
Yes.
militate against the idea that we have to look at each parcel separately. Because if we're going to look at each parcel separately, then we don't consider the square footage associated with the proposed detached garage because it's on the other property.
Well, so I believe to answer that for lot coverage, the first example only considers the construction that's going to be on 161.
Thank you for that clarification.
Yes. Thank you for helping me make that clarification because I wasn't sure where you were going with that. But yeah, so the architect, they separately parsed out what the lot coverage was just on 161 with only the construction on 161 included.
So this coloring has nothing to do with the square footage that was considered for the purpose of this exhibit presented at hearing?
Yes, correct.
Thank you.
So really, I mean, the two issues are lot coverage, and again, when staff is reviewing an application for consistency with zoning regulations, they look at it by strap. So when staff would review this, they would consider that the lot coverage would be 42.5% for 161 Gilchrist. And then regarding size, again, using the gross building area, which was the numbers presented by the appellant, the proposed construction is at least 24% larger than other proposed or approved new constructions within the surrounding area. So that pretty much concludes my case. I feel like there was substantial public testimony that could constitute competent substantial evidence based on the residents' personal knowledge of the bench and or the historic district. But the hearing examiner doesn't even need to consider those because I think the competent substantial evidence was presented by appellant's team regarding the historic nature of the bench, regarding the lot coverage of the house, and regarding the proposed mass of the new construction.
Thank you.
Very briefly, thank you, Madam Hearing Examiner. I will address the points in turn just to keep everything organized. So it is undisputed regarding the bench. It is undisputed that the property owner did have a legal right to remove that bench. Ms. Swindell did read that design guideline, and during the hearing, Ms. Swindell, as well as Mr. Blackwell, explained to the board that there is no protections to the bench and provided a couple of different avenues of what could be done. But in any event, the board denying the application based on the bench did not take any steps to preserve the bench. And finally, regarding that point, board member testimony, it has been held by this hearing examiner as well as other, as well as courts, that board member testimony or board member discussion does not amount to competent substantial evidence. So turning to 4.1, guideline 4.1, that is, when Ms. Swindle is referring to lot coverage, I just do want to kind of clarify some points. I think it was clarified on the record, but looking at Exhibit 4 that Ms. Swindle just handed us, this does include, that spans across 161 and 181 Gilchrist. So, Madam Hearing Examiner, you were correct that that square footage that's included there is not just one lot, that's 2 lots. Which makes this property different than 200 Banyan, 211 Banyan, because those lots are half the size than the current proposed construction. Moreover, although there was included in the applicant regarding looking at, this is labeled as Site Plan 102, what Ms. Swindle handed out, that the lot coverage of 161 alone, but it's clear that this project, this proposed construction, is spanning across the 2 lots as one construction. The only reason why the appellant had to bring forth 2 separate cases is because 181 Gilchrist was deemed a contributing parcel. So we first had to file a request to change the status and then demolish the structure that is located on 181 Gilchrist. If they were both non-contributing parcels, it would have been brought as one SCA application. But just so from background, so when looking at the proposed construction, it is the single-family residence, 2-story single-family residence that sits on 161 Gilchrist, which is Gulffront, but some accessory structures on 181 Gilchrist. So as you can see here, what's included in the SCA application is that garage, and I believe there's like an equipment yard, mechanical yard, such as AC and things like that. So because the proposed construction spans across the 2 lots, those 2 lots are being used in unison, you would look at the lot coverage of both of those lots combined, which is 27%. And again, looking at the numbers, fortunately we did have expert testimony at the hearing provided by the architects as well as certified planners that really demonstrated that the gross square footage of 200 Banyan Street, and this is not included on this exhibit, but this was testified to at the public hearing and included in the record, that 200 Banyan Street is much more akin to 11,000 square feet, including the under AC as well as the non-AC. So the under AC is the 2nd floor, and the non-AC section would be that bottom floor. So taking those 2 combined would be 11,000 square feet, which is consistent with the proposed construction. So we do argue that the board did fail to apply the correct law, and there is no competent substantial evidence to support the denial. Thank you.
Okay, thank you very much. I appreciate everyone keeping their remarks brief and sticking to the record. I am very familiar with this case. I've had an opportunity to thoroughly review all the documentation that was submitted in the course of filings. I appreciate the clarification and the crystallization of your arguments, and I hope to have a decision on this case in the next 2 or 3 weeks. Thank you.